1, Episode 1.
Hello. Awareness Train and Mommy on a Mission is addressing Congressional Law HR-867. H is in Henry, R is in Romeo, 867. This law passed in 1997 during the Clinton administration, and it gives federal kickbacks to Child Protection Services, or CPS, after parental rights terminations, PRT. What could go wrong? Well, many thousands of Americans have something to say, especially when termination versus reunification is the dominating factor in family court. Thousands of parents and children's grievances get buried without due process, okay? Are you paying attention? Please stand up publicly, unless it risks your case, or maybe you might choose to be anonymous. Just know that you can stand alone with ample signs. You can stand together with ample people. Be heard. Whether you run, walk, or crawl, parents for reunification need to keep moving, okay? Families in every state of the nation feel like wounded warriors. The time for change is now. Reform HR 867. Reform and audit CPS, Child Protect Services, sometimes a division of DHHS, Department of Health and Human Services. For the hearts of the families and children, please hear these cries. They're calling on all able-minded and caring people. Will you be informed? Will you stand on the front lines? Critical mass awareness is needed. America's children who have aged out of the foster care system are begging for truth, liberty, justice, and you know what? Most of all, reunification for the silent victims who are still in the CPS prisonhood gauntlet. If you've ever been affected or have loved ones who have been negatively affected related to this sensitive topic, please reach out to us. If you want to be heard or offer your support, communication guidelines are expected and protected. Your anonymity requests are fully accommodated. Hearing and visually impaired followers will be accommodated upon request if they aren't otherwise being accommodated. Speech during podcasts may be slower than typical in consideration of our hearing impaired followers. Make sure you follow us on Twitter, Mommy on a Mission 5, Facebook, Awareness Train. This is the one that's got a rally photo that's got a black and white sign on it. We do have a YouTube channel that hasn't had a whole lot of activity, as is this new podcast that I'm introducing. We do put links in the descriptions of our social media, so don't forget to like and subscribe. Thank you for listening with Awareness Train and Mommy on a Mission. Stay informed. Until next time.
Sorry is always dangerous. It attracts the west and corrupts the best. I never asked to keep the hope. God is only given to those who are prepared beyond themselves to make it up.
awareness train and Mommy on a Mission wanted to address Congressional Law HR-867. This is a congressional law that gives federal kickbacks to Child Protection Services, CPS, during foster care and after parental rights terminations, PRTs. What could go wrong? Well, that's what we'll be discussing in our future podcasts. Would love it if you'd like to listen in, reach out, submit your story, or positive input and support. Anonymity is always respected. This is a federal law that was passed in 1997 by the Clinton administration. Many thousands of Americans do have something to say, especially when termination versus reunification is the dominating factor. I've mentioned this in my introduction podcast. There are thousands of parents and children's grievances that get buried without due process. Are you paying attention? Please stand up publicly. Unless it risks your case, you may choose to go anonymous. Reform HR-867 and audit CPS, Child Protection Services, Division of Department of Health and Human Services. For the hearts and families of the children, please hear their cries. I'm going to go ahead and take a moment to read this particular law, Titles 1 and 2. It's called Title 1, Reasonable Efforts and Safety Requirements for Foster Care and Adoption Placement. Title 2, Incentives for Providing Permanent Families for Children. For the Adoption and Safe Families Act of 1997. Title 1, Reasonable Efforts and Safety Requirements for Foster Care and Adoption Placements. Amends Title 4, Part E, Foster Care and Adoption Assistance of the Social Security Act to emphasize that in meeting the reasonable efforts requirement of the family preservation and reunification, the paramount concern of state plan for foster care and adoption assistance shall be the health and safety of the child. States that reasonable efforts to preserve and reunify the family shall not be required on behalf of certain parents, including those who have murdered or committed felony assault against another child, or would be otherwise pose a serious risk to a child's health or safety. Declares that nothing in such act shall be construed as precluding state courts from exercising their discretion to protect the health and safety of children in individual cases, including cases other than those described in the Act. Section 102 includes the safety of the child in state case planning and review system requirements. Section 103 delineates circumstances compelling a state to file parental rights termination petition and concurrently initiates selection of a qualified adopted family for certain children in foster care under state responsibility. Section 105 makes federal locator service available to child welfare services enforcement for custody or visitation orders. Section 106 requires state plan for foster care and adoption assistance to provide procedures for criminal record checks for prospective foster and adoptive parents. Section 107 requires a case plan for a child for whom the state's goal is adoption and placement in another permanent home to document state agency efforts to accomplish that goal. For Title Number 2, Incentives for Providing Permanent Families for Children, authorizes the Secretary of Health and Human Services to award an adoption incentive grant to an incentive-eligible state. I repeat, authorizes the Secretary of Health and Human Services to award an adoption incentive for incentive-eligible states meeting specific criteria whose number of foster children or special needs adoptions for a fiscal year exceeds a base number calculated according to a specific formula. Includes among such criteria the provision of state health insurance coverage for the children with special needs for whom an adoption assistance agreement is in effect between the state and adoptive parents. Section 201 authorizes the Secretary to provide technical assistance to states, local communities, and courts to reach their targets for increased numbers of adoptions and alternative placements for children in foster care. I repeat, Section 201 authorizes the Secretary to provide technical assistance to states, local communities, and the courts to reach their targets for increased numbers of adoptions and alternative permanent placements for children in foster care. Authorizes appropriations FY for year 1998 through 2000. Section 202 requires a state plan for child welfare services to contain assurances for state plan development using cross-jurisdiction resources to effect timely adoptive or permanent placements for waiting children. Denies federal assistance eligibility where a state has impeded the placement of a child for adoption outside of the jurisdiction with responsibility for handling the case. Instructs the compeller to general study and report to the Congress on improved procedures to facilitate the interjurisdictional adoption and permanent placement of children. Section 203 directs the Secretary of State to develop a set of outcome measures for rating state placement for adoption and foster care, and to report annually therein to Congress, and to develop a performance-based incentive system. I repeat, to develop a performance-based incentive payment system. There is a lot of money exchanging hands when there are incentives to take and keep children from families, and families are reporting that they're not getting due process, they're not being heard, their children are being abused in foster care, the parents are collecting evidence and providing it to their court-appointed attorneys, otherwise known as CAT, C.A.T., and families are claiming that there is no due process. Some states have a backup outreach that takes interviews with parents who claim that they're not receiving due process. This entity is a division of the state, and they don't assist families in any way. So when there is no audit of this system that involves all this money, there's a bit of a concern. When I began reading hundreds and hundreds of stories, testimonials, I've looked at Supreme Court appeals court cases where parents were trying to appeal their terminations. The Supreme Court upheld all the lower court decisions. The parents didn't get their children back. And looking at similarities in people's stories on a national level, I'm seeing a shocking amount of identical conflicts and barriers that thousands of families are expressing that they're feeling. I have attended state meetings where oversight committees were reviewing Department of Health and Human Services as a result of several deaths that have occurred. When there are over 3,500 children in CPS custody and only 1,500 foster homes and 99 beds in youth behavioral health facilities, there's a serious problem. When reunification is no longer a viable option and court-appointed attorneys don't have the time to go over the mountainous amount of evidence that is constantly compiling against these families, much of this evidence is false. Families are claiming that reports are not accurate, that court-appointed attorneys are not effectively defending them, that the guardians ad litems are initiating and pushing for termination, refusing to report accurately the child's complaints of abuse, neglect, hiding or covering up medical records that would verify abuse, neglect concerns that are reported by parents, not removing children from homes where there is jeopardous exposure, and things like that. You may ask yourself, why haven't I heard of this? I thought CPS was about protecting children. Well, maybe they initially were founded for that purpose, but with no one auditing expenses and millions of federal dollars in kickbacks that initiate the sale of our children to foster homes, that's a concern worth discussing with the families.